Constitutional Court set to hand down judgment on former President Jacob Zuma's application to rescind his contempt of court conviction. Just last month, you remember, the Apex Court asked Zuma's legal team as well as other parties to make submissions addressing international law and constitutional implications of his detention. So we ask, is this order and the judgment even rescindable? To help us think through these legal matters, let's bring in Professor of Public Law at the University of Pretoria, that's Koos Malan, who joins us now via our video link. And Prof, it's great to see you again, especially on this issue. Thanks very much indeed for making time. Let me begin by just gauging to what extent you think today's outcome is a far-gone conclusion.
It is not necessarily. Will it have? Is it something with a foregone conclusion? There's a lot of pressure at the moment on the Constitutional Court because the Constitutional Court has taken quite some hammering, its reputation as well as its own integrity. And it has taken that hammering precisely because of the way in which the court conducts itself. On the previous occasion, I think I did comment on that by saying that this is actually an application for a retrial, masquerading as an application for a rescission. And this boils down to nothing but an abuse of court process, because nobody should be entitled to a retrial in circumstances like these. So the mere fact that the Constitutional Court has decided to actually hear the case again is something that, to my mind, tarnishes the reputation and also inflicts blows upon the integrity of the Constitutional Court. And precisely for that reason, the Constitutional Court, together with Mr. Zuma, in a sense, is on trial. In the sense that what the Constitutional Court will be doing today, what its judgment will be today, will be focused upon by constitutional jurists, by the public, by politicians, and so on. And the judgment will have been such that the Constitutional Court, in a sense, restores its integrity. So that applies both to the actual outcome of the case. In other words, whether this application will be succeeding or not, and secondly, also to the reasoning of the court.
Right.
In a sense...
Sure. If I can come in there, Prof. Let's actually break down what the former president is asking for here. He's asking the Constitutional Court to do two things mainly. One, review the guilty verdict of being in contempt of court, and two, review the 15-month jail term. With the former, let's just say, for the purpose of our discussion, it's much easier to ascertain whether or not he was in contempt. There was an order given, he didn't follow it, and so many people, I think, are likely to say that's pretty far gone. But when it comes to the sentence, though, help us think through how the Constitutional Court would even change that sentence without setting a dangerous precedent about essentially what the consequence of being in contempt of court actually is.
Yeah, I think that's a very crucial question. I think the Constitutional Court at this stage is, however, in a good position, not so much from a legal point of view, but in a sense from a political point of view. Because you know what constitutional jurists, with all due respect, very often fail to tell you is that cases of a constitutional nature is obviously judged against a particular political background. And the political background since the judgment was given in the first place until now has changed. And the most important change that has taken place is that a parole was granted to Mr. Zuma. So in a sense, a lot of political pressure has been relieved from the Constitutional Court, because regardless of which way the case might be going today, whether they change the actual term of the sentence from 15 months to something else, would have, to my mind, so it appears, at least as things stand at this stage, will not have practical consequences in the sense that Mr. Zuma is already out of jail. But that does not mean that its verdict today on the question of the sentence will not be important, precisely because of what you've said, of the question of the president, that the precedent that is being set here.
Sure.
But the pressure as such, concerning Mr. Zuma's own practical position, that pressure is actually off the Constitutional Court at the moment.
Fascinating. The other circumstance that's changed, of course, is that the former president has already spent time in jail. In other words, even if this order was to be rescinded, it almost feels like because he spent time in jail already, it would be seen as a massive injustice. Could that have a bearing on how the court sways today?
It should not have. It should not have. There are two factors. The one thing is how the court actually articulates itself, and the other thing is that very often comments are made on that, on what the court actually do not say. Very often some of the considerations, all the considerations that should be taken into account and that do determine the outcome of the case should be articulated, but often that actually does not happen. The most important thing at this stage, to my mind, is that the court must restore its own integrity, and precisely for that reason it will have to give a good, reasoned judgment. And the most important thing that the court will have to explain to us today, and I think there's a lot of eyes on the Constitutional Court for that, is to actually give an explanation right at from the outset of why it has given Mr. Zuma the opportunity for this, as I've said, retrial. Because the main focus of criticism against the court was on that question. So in other words, to my mind, from a legal point of view, the actual important thing today, taking into account that Mr. Zuma is already out of jail as a result of the parole, is not so much the actual verdict on the actual sentence, the term of the sentence, but the motivation that the court will have to give why it was prepared to go for this retrial process again. Because that is really the important thing that sets a very dangerous precedent.
Yeah.
And I think the court, there's a lot of pressure on the court to actually explain that.
Right. Why open the door for this application to begin with is essentially what you're saying, Prof.
Yes.
There are some people, I imagine, just at the top of my head, who might say, well, it might be because the court wants to ensure that justice is not only done, but is also seen to be done. In other words, they don't want anybody to come back a few days, weeks, years later to say that you didn't even hear this application, so why should we trust that this court order can actually stand being challenged, that its muster will actually hold?
Yeah, well, you see, precisely for the same reason, the court should not have entertained this matter, because that opens the door for any other person against whom a sentence has been given, even the court of final appeal. It opens the door that all such courts will now have to reconsider all such matters. The question that arises here is, and questions are already posed on that, is this opportunity has now been given to Mr. Zuma, and we know it's a politically very sensitive case. We know it is something that has a bearing upon the position within the ANC, the so-called faction strife within the ANC. But people could argue very convincingly that since this almost privilege was being given to Mr. Zuma, why not to me? Why not to me as the common man in the street, as a person who is just a normal offender? Why reserve that kind of special treatment only for Mr. Zuma against the background of the problems within the ANC? That's the actual problem. So coming back to the phrase that you've used, namely that justice has to be seen to be done. Well, justice has to be seen to be done precisely in such a way as to see to it that people could not be entitled to a retrial in each and every case. While this should not apply to Mr. Zuma, it should also apply to the public in general. I think that's the most important thing.
You've mentioned already that, what judges sometimes do, and perhaps rightly so, is consider the circumstances around the case, especially if they're going to hear it again. There's a lot of people who believe that the riots we saw in July are a direct result of Zuma being jailed. To what extent do you think that will inform what we hear at 10 o'clock today?
You see, that's a very interesting question. On the one hand, that should not be playing a role at all. The basic idea surrounding adjudication is that courts must only take into account the relevant facts, okay, and the relevant facts only pertain here to the alleged offense of contempt of court and the relevant law, namely the legal principles applicable to that particular question, namely contempt of court. Because a court is a court of justice, it's a court within which legal principles and nothing else should be taken into account. Otherwise, you don't have a court of law, but a court of politics, a court of equity, and so on. While, strictly speaking, we are dealing here with courts of law. So in a nutshell, that should not be taken into account at all. That consequences are something to be dealt with by the president, by government, by the relevant state departments, and so on. That's the theoretical position. But I can imagine that obviously the court will have will also consider, even though not specifically articulated, that this whole thing is playing out within this very sensitive political milieu that we are in fact in at the moment. That is something the court will not actually say. I would be very amazed if the court does articulate anything in that regard. But at the background, I think that is something at the back of their heads that will be playing a role.
Fascinating discussion, if I say so myself, and what a time to be alive. Koos, Malan, thanks very much indeed for your take on this incredibly important story.